Good afternoon, everyone, and thanks so much for joining us live for a really exciting In Conversation with Professor Sue Harris-Rimmer, who is the independent reviewer of the Queensland Human Rights Act, and that review is currently ongoing. I'd like to begin by acknowledging that we're meeting on the land of the Turrbal and Yagara people here in Brisbane, and I'd like to pay my respects to elders past, present and emerging, and as well to any First Nations people who are joining us online, and acknowledge the traditional owners of all the lands you might be meeting us on from. Also, today kicks off National Reconciliation Action Week, and the theme is now more than ever, which is really relevant to today's conversation. And we'll get into this more, but the theme really is about now more than ever, the fight for First Nations justice and rights must be continued, will continue, and hopefully Sue, through this conversation, will have the opportunity to talk about how that could be achieved through strengthening Queensland's Human Rights Act. I also just wanted to say that as part of Reconciliation Action Week, QCOSS is hosting a webinar on Friday that will look at the importance of First Nations-led responses to youth justice in Queensland, and we'll share the details of that in the chat. We'd love for you to come along to that too. So it was in February, the 27th of February, that Professor Sue Harris-Rimmer was appointed as the independent reviewer of Queensland's Human Rights Act. What an excellent choice. Sue is well known as a human rights expert, an expert on gender equality and climate justice. She's the perfect choice for the review, and someone QCOSS has worked with for a long time, so we're delighted by that appointment. It's also really exciting to be talking to Sue today from a personal perspective. For those of you who don't know, prior to being appointed into this role at QCOSS, I was a lawyer and worked with lots of other wonderful people, hopefully some of who are joining us online today, to lead a campaign to achieve a Human Rights Act for Queensland. And what we achieved was not perfect, but it is the Human Rights Act that we are reviewing, and it was at the time sort of talked about as the strongest human rights protections in the nation, and there were some mechanisms included that hadn't appeared in the Victorian and the ACT model. But we did know at the time that we didn't get everything we wanted into the Act, and we were really clear that we wanted a review. So to be part of this conversation now with Sue is incredibly exciting for me personally. It is the case that we've seen since the introduction of the Act some really positive changes here in Queensland in terms of human rights protections, and I know, speaking to our members, that many organisations have looked at their policies and practices to improve their human rights respecting nature of their organisations. I've also heard tremendous stories of individuals being able to assert their rights successfully because of the Human Rights Act. But we also know that it's failed us on many occasions, and there are many human rights that still are not adequately protected or respected or fulfilled in Queensland. So hopefully this review presents us as an opportunity to both reflect on the things that are really important and we want to retain about this legislation, as well as the things that we could improve. So QCOSS will be making a submission into the review that Sue's leading. We're really grateful for the support of Clayton Utz lawyers, and there may be some of those lawyers joining us online today, and I just want to say thank you so much to Clayton Utz for assisting us. We will be doing a comprehensive submission based on member feedback and the advice from Clayton Utz, but also we'll be producing a template, and we'll be kicking off a working group for anyone who's working on a submission to the Human Rights Act review. So I'll remind you of that at the end, but we absolutely, as an outcome of today, want to collect your insights to include in our submission, but also really encourage you to get on board and participate in the review. Just a few little housekeeping items. We are broadcasting live in Teams. We have the Q&A section activated. Sue and I can see any questions that you have coming through, so please do ask your questions, seek clarifications, We've got quite a bit of time together, so we're really going to try and get to some of those live questions. We'll do our best anyway. And just wanting to flag that this session is being recorded, so bear that in mind in your participation in the webinar. So, I am absolutely delighted to welcome Sue, who has joined us today at QCOSS, to talk to us about this incredibly important review. Welcome, Sue.
Hi, so wonderful to be here.
So, Sue, can we start? I mean, I've talked about how excited we are to have you do the review, but can you talk to me a little bit about your motivations in sort of putting your hand up or being willing to conduct this review?
Absolutely. First, may I also acknowledge the country on which we are hosting this webinar, and I pay my deepest respects to the Yuggera and Turrbal people, and I pay my deepest respects to anyone joining us, and I always pay my respects also from the land I'm from, which is Coonabarabran, with Wiradjuri and Gamilaroi people in the beautiful Warrumbungles. That's part of, I think, of my journey. I'm from a very small country town called Coonabarabran. I'm a very unusual human rights lawyer. I always say, I'm the human rights lawyer from Coonabarabran, because as far as I know, there ain't any others. So I suppose I've always been very interested in bringing that voice of people who maybe don't live at the centre of things, who have a lot of difficulty accessing information, resources, who live in, quite a lot of poverty, who live in essentially places that have felt forgotten maybe by the rest of the world. And that's my childhood experience, but it was also a very beautiful place with a lot of its First Nations culture intact. And so when I went to law school here in Brisbane, so I am from New South Wales, sorry about that, but when I first moved many years ago now to law school, I really, out at St Lucia, I really made a bit of a pledge to myself that my legal career, or my amazing opportunity to go to university, which had never been experienced by anyone in my family before, that was going to be my chance to really focus on what I care about, which is people's human rights and social justice. And there is so many challenges in this nation, but there was a lot of challenges for this state, its history. Thinking about when we went to uni, it was still, we were protesting the right to protest, and there's just a lot of emotional journeys we have to go on. I've been thinking about my colleague Josh Creamer, who's also from Griffith University, is running the truth-telling process, is chairing that inquiry with a lot of amazing people. That is such a difficult journey for the state. You saw it during the Voice campaign. There's still a long way to go for us to really think about what human rights means and for whom in this place. So my motivation is about a situation where we can really think about the Human Rights Act and how it can become much more meaningful for people, can achieve better results for people, and can be very place-based. So I want to deeply contextualise understanding of the Human Rights Act in this state, in these places. I'll be going up to the Torres Strait and to Palm Island and to Cherbourg. I did a lot of work last year in Birdsville and around the state where, because I like the small out-of-the-way places, because that's where I'm from too, where it's got to be meaningful for every citizen of Queensland. And also I'm very interested in the culture of human rights inside the public service. So I'm really interested to see whether we can make the integrity of public decision making be more naturally aligned to human rights decision making. So you've come a long way around integrity issues in this state. I want to see those two things really well aligned. Good, transparent, ethical decision making takes into account human rights. I want that to be really well understood inside government, and it's one of those things that really motivates me, that sense of human rights is also about ethical integrity, compassionate decision making, inclusive decision making. So I'm really interested in that kind of lens as well, as someone who was a former public servant. That's very important to me. So I'm quite interested in it being quite a practical review. I really want it to be quite grounded in practical ideas. And that's why this QCOSS audience is so important to me. If the Act is going to be meaningful, it's because of our community organisations. We know that. We know the part community organisations play in times of emergencies. We know the part they play in times of non-emergencies. That lifeblood of communities. Your organisations are going to make the Act succeed or fail. So this is the really key community of practice for me to talk to. So I'm very genuinely here to listen, to amplify your voices and to take as much as we can of the direct voice of community into the report. The report will be tabled. I can't guarantee what happens after that, but we can make the strongest statement we possibly can. And that's also us. Basically our debt to future generations is doing the very best that we can. And that was always the idea around the Human Rights Act. Let's try our very best to put our mark for future generations to say, we tried at this time, this is what we did. This is what we tried to achieve. And it won't be perfect, but we really did a good piece of work, I think. And it was a beautiful feeling, everyone coming together for that goal. So it's time to do that again and try to make the Act even more meaningful and work for people in the way it was intended.
Yeah. So Sue, I think there's a picture of us standing outside Parliament when the Act was passed. And so when we talk about reviewing the Act, it's not as if your review of the Act commenced in February this year. So my question to you is, what have you observed about the Act so far? What are the things, where have we seen the greatest impact? What are the implementation challenges? What are you thinking about it going into the review?
So when the Act was passed, I thought the biggest challenge to the Act was going to be the new complaints mechanism, because we hadn't had that in any other jurisdiction. It was new, it was novel, and it certainly has been challenging, but not for the reasons I expected, because straight after the Act was passed, we went pretty much smack into COVID a couple of months later. So it actually entered into force 1st of January 2020, and then a couple of months later, boom, right? And so the Act received hundreds of, thousands of complaints around hotel quarantine and vaccine mandates and everything to do with freedom of movement and those sorts of things. And it's unlike any other new piece of human rights legislation in the world, because it went smack into the pandemic. And I thought the Act might be suspended, but it wasn't. And so you had this, exactly what the Act was intended to do, this difficult dialogue between two sets of rights, the right to life, the right to health, but also these other rights that are very important about the right to family life and freedom of movement and freedom of association, all those difficult things. So, but it became an Act that was for mainstream people. So everywhere else, where I'd worked with Hilary Charlesworth in the ACT in the first review of the Act there, it was really the only people using the Act for years and years and years were prisoners on bail applications. It was the same in Victoria. It took a long time for people to use the Act, and even then it was kind of people who were in really desperate straits on the margins of various difficult situations. It wasn't kind of the average mum and dad, So it was a really interesting start to life for the Queensland Human Rights Act. And there's been so many natural disasters that have not just the pandemic, but floods and cyclones and heat waves and all sorts of things that have happened since the Act was passed. We seem to have been in a bit of a state of polycrisis. We weren't thinking about the Human Rights Act being important to an Olympic bid. There's been a lot of things that have happened. And at the same time, the Queensland government has had some really different, some seismic changes around the way it thinks about the public sector. So it's got a new Public Sector Act. We've had the cold rate review, let the sunshine in. We've had a whole range of issues go to the CCC. And we've had some really serious human rights problems, including the unbelievable stress on housing. We've had some very serious issues with the rights of children and youth justice, and I'll talk a bit more about that. We've also had some incredibly difficult situations around domestic and family violence in this state and nationally, and we've had some really very fundamental pieces of legislation around voluntary assisted dying, abortion rights, and a complete revamp of the anti-discrimination bills that are going through. So it's been an incredibly full-on period for a new act to work in, and I think that all that initial momentum has been somewhat undermined by the suspension of the Act around the youth justice issues. So I think it's really important that when we're reviewing this Act, we think quite carefully about, as I said, the Queensland contextual nature of this piece of legislation. Yes, it has a lot of the same provisions as Victoria, but it has a very different set of history, context, circumstances. So that's what I'm really interested in exploring. But yeah, it's been a wild ride. We've also had some really intense decisions already. So we've had Waratah Coal, we've had the vaccine mandate case, which was more procedural. We've had some really important prisoner rights case. So it's been active in the courts as well, much earlier than the other jurisdictions.
Right. So what I think, what are some of the things, I guess, that you've seen? You've sort of spoken a lot to sort of the contextual issues that the Act has interacted with. What are some of the things that you would call out as the biggest impacts you've seen through that interaction?
So far, I think, the fact that the complaints jurisdiction has been very meaningful in the sense that people have made complaints to the point where the Commission may not be able to keep up with the complaints that it's been receiving. So that's a really interesting fact. We want those complaints to become part of a feedback loop where we really start to understand, are the complaints showing a pattern? Can we use the complaints function to play that prevention role? What we want with the Human Rights Act, what we were always dreaming of, was a situation where the combination of the complaints function, the statements of compatibility function for legislation, and the enhanced parliamentary scrutiny, we want to prevent human rights issues happening to anyone. We want to, stop people having to go to the Supreme Court, right? The whole point of the Act is not for people to go to the Supreme Court, it's so they never have to go to the Supreme Court to have their rights upheld. And we're slowly moving in that direction, but we still haven't quite got that yet. Yes. So, and then we've got some special terms of reference that the Attorney General has given us. One of those is around the suspension of the Act around the Corrections Act and the Youth Justice Act, and these current changes that are also in front of the Parliament. They will be outside my remit. My remit goes up to the 30th of June 2023 because that's the period in the Act. But certainly the previous suspensions of the Act will be in my purview. So the ACT Act doesn't have an override provision, Victoria does, but our Act also has a lot of limiting provisions, things that allow the limiting of rights and the balance of rights, but these override provisions are, I think, quite demoralising for the sector, is what I've been hearing. This idea of that evidence-based policy can be thrown out the window.
Yeah.
It's been demoralising not just for those issues and for the most vulnerable of people. Children in a detention setting are high risk. That's exactly what human rights protections are for. That's who we're looking to protect the most, is children in detention settings. So that's been quite a demoralising issue. So the question is, how do we make recommendations that really push back and speak back to and raise the political stakes of doing that in the future? So there's some things we can do. We could say you just shouldn't have override provisions. I mean, in the ACT, you can have a statement of compatibility that says this is incompatible, and the ACT government could go ahead anyway. They never have done that, though. And in Victoria, they have overridden the Act twice. They've both been for people convicted of killing police and going on bail. That's who the Act has been overridden for, those two individual cases. but not the sort of blanket sort of overrides that we've had around a whole category of people and very vulnerable people. The other term of reference that we've got that's a bit unusual is victims' rights. So the Women's Legal Safety Task Force, which you've written an amazing report, has asked us to look at the relationship between the Charter of Victims' Rights and the Human Rights Act. So at the moment, the Charter of Victims' Rights goes nowhere. You can't use it. It's there, but you can't actually complain about it or do anything with it. The new Victims Commissioner, I think, will be appointed soon. We have an interim commissioner. What is the relationship of that regime with the Human Rights Act? If you look at our right to a fair trial, in the ACT it's written as everyone has a right to a fair trial, which could be interpreted to say that includes victims and they should be supported through trial processes in the same way a special witness is protected under the Evidence Act to give certain types of testimony. So that might be one way of looking at it, reinterpreting the rights that are already there to be more victim friendly or victim focused, or it could be a better process between the Victims Commissioner. We have to really think through what and this is what I want to hear from QCOSS members, what is going to be the most use to victims, and which victims are we talking about in relation to the Human Rights Act? How, should it just be people who've suffered personal serious harm? Who are we talking about, and what types of rights should they be accorded, and where should they sit, I suppose, in Queensland legislation? So I'm very influenced by the EU victims' rights charters, which are enforceable. They're legally enforceable across the EU. And I've been watching the Brittany Higgins trial and many others to think about this. How do you support victims through various processes, and how do you balance that with the rights of the accused in an appropriate way? And how is this all going to work? Right. But I think that a right to a fair trial is, we do not look at that through the lens of just the accused anymore, because we understand how trials affect people in domestic violence or sexual abuse situations. We understand what it's like or what the process has been like for those people undergoing trial. So that's a big one. So I'm really interested in what people think about that. And then under the actual Act, it says we have to consider future rights and new rights, and that's exciting. So we're putting together a discussion paper at the moment, which is about the rights that they have in the ACT and Victoria that we didn't get in Queensland, and there was a lot at the time in the inquiry about people asking for various rights that weren't included, especially some of the economic and social rights, like a right to housing. ACT has wrongful convictions. There's a few, and also ACT is about to pass the right to a clean, health and safe environment. So there's been some activity overseas around digital rights, again in the EU, which is very interesting. So we've got a mandate to look at new rights. So that's an exciting and creative area for our members to think about. And then finally, I was allowed to choose some of my own. I'm really interested in this idea of, what are the greatest human rights challenges that the state faces? I feel like the Act needs to be understood in that context. So I want us to be saying, here are the major challenges Queensland is facing in terms of human rights, naming those issues. Is it dispossession of First Nations people? Is it and their dignity or their right to self-determination? Is it the rights of children in out-of-home care? Is it prisoners' rights? Is it LGBTIQ rights? What are the rights that are under pressure in our state? Let's think about them. Name them, think about them, have a bit of strategy around how we're going to address those, really address the promotion and respect of those rights over time. So I want us to do a bit of truth-telling in our own way. And we also know about who's living in poverty in our state, which itself is a breach of human rights. So, those sorts of things we can really start thinking about a little bit more deeply, because I'd like the Act to be more contextualised into what sort of Queensland do we want to live in, and what does it look like, and who is benefiting and who isn't from the current status quo. So, really contextualised conception of rights. The final one is is because I'm a bit obsessed with human rights and sport. So I really do. We are going to host an Olympics Games. It's going to be a big deal for a long time to come, and it is an opportunity to have a lasting legacy around human rights that can impact a lot of different jurisdictions. So that's one I'm really keen on. I did the FIFA Women's World Cup Human Rights Assessment and the Commonwealth. I was the Human Rights Advisor to the Commonwealth Games. So there are some place-based and temporal benefits you can get out of these major sporting events, but they can also be terrible for human rights as well. So that was my captain's pick.
Wow.
Yeah. So
Sporty Sue.
Sporty Sue, I know. Who would have thunk it? But there you have it. And it's also something I feel like a lot of Queenslanders might be able to get behind.
Yeah,
if they don't have deep obsession with any other part of the Human Rights Act. Maybe they're interested in human rights and sport. So that's the plan.
Amazing. I think it's incredibly exciting to hear this sort of thinking about how we continue to evolve human rights law, because the starting point is after the Second World War, and it's about how we limit the states, how we regulate that relationship between the state and the citizen. And as we know, Sue, that those laws were developed, in a patriarchal society where we were concerned mostly about human rights issues that occur in the public sphere. And while you're looking at your environment and really being contextual, what do we understand the state's role in terms of keeping our communities safe and well, regardless of whether they're in the public or the private sphere. And some of what you've talked about really starts to grapple with that.
Well, if you think about COVID, because we didn't do the gender analysis we should have, and I don't lay blame for this, it was all happening very fast. But at one point, Queensland was losing more people to domestic violence issues than they were through COVID, the disease, because of the lockdown requirements. And that is so tragic, right? We're still really grappling with this notion of what it means to take women's lives really seriously in terms of human rights. There will be a strong theme in the report of gender equality, of all gender identities and sexual diversity as well. But this idea that we have had this idea that law has been designed for these particular class of people, able-bodied, cisgendered, white people for so long, and we can't seem to unravel it the way we should. And the human rights legislation should be a way of trying to unravel it, unpick it, broaden it. And that should be what it's for. But I would think that the most people who've complained to the Human Rights Act are people who've got time and wealth and access to information and literacy, and there's so many barriers to basically engaging with the state. There's so many. So we want to really make sure that we try to break down as many of those as possible with these processes.
And I think some of that sort of, I guess, what I love about the way the framework works is it doesn't sort of rule out any legitimate public policy objective. So it requires you to sort of define what you're trying to achieve, and then look at what's the least rights limiting option, and actually provide evidence that you've looked at the options and that this is the best option. And I think, I'm not sure whether you can reflect on this, Sue, but when I've read statements of compatibility or other explanatory memorandums, I think we're still developing as a state in terms of our ability to apply that sort of thinking. So I guess that's about the policy making, law making piece, and then we've got the bit where a public entity has potentially limited rights, and we want a recourse for that for individuals, and people can currently complain to the Queensland Human Rights Commission, or they can take legal action if they can piggyback it or attach it to another sort of cause of action or ability to take action in the courts. So there's some clumsy kind of bits in there, isn't there, in terms of access to justice and making sure that everyone in our community is able to both understand and use the legislation in a way that both prevents human rights issues from occurring, as well as when they do occur, allowing people to take action. What are some of those kind of mechanisms that you're going to be looking at, and do you have a sort of sense of where that might go?
Sure. So we've been asked very specifically to consider remedies. So, you know, it was a real sticking point when the Act was passed. Most of us were pretty firm that we wanted there to be human rights to be treated like any other cause of action in Queensland, and to be allowed a chance to go to QCOSS or the Supreme Court, and for the ability to claim damages. That's not what we got. We got the same as Victoria and the ACT. But now the ACT has changed. They have a direct right of action to the Supreme Court with limited damages. As I said, you can claim compensation for wrongful convictions in the ACT. So there is a different sort of thinking happening there, and it's about thinking. For me, it's exactly the opposite of what it should be, right? A violation of human rights should lead to a better treatment by the courts and the process, and the more likelihood of damages instead of being cut off. So it's a bit of a strange situation that say a human rights breach is the poor cousin of a discrimination breach. It doesn't make sense, you know, especially when discrimination and rights are so often together. It's very odd. So trying to make sure that if the discrimination bill goes through, the Human Rights Act is much more aligned and much more equal in the way that it's treated, and that people don't have to do the hard work to figure out themselves, what do I have here? They should just be able to complain, and someone behind the scenes should be able to figure it out for them. So we certainly are looking for things about remedies. So what type of remedy do you think is appropriate? So some of the things we've been thinking about are, should it just go straight to QCAT, like a discrimination claim? Should there be a specialised tribunal? That's been a very popular idea, that it's a specialised knowledge. It should be more like the Domestic Violence Court or the old Tenancy Tribunal or the old Discrimination Tribunal, where you had people who had specialist training. So you could have, say, human rights, discrimination, restrictive practices and some supported decision-making cases that really require deep human rights sensibilities. You could have that on a panel at QCAT, or you could have a specialised jurisdiction, or you could allow a limited direct appeal to the Supreme Court with limited damages like they have in the ACT. So there's a few options there. Really keen to hear what people think. Or you like the current situation where there is no remedy, tell me that too. Then the first part was about, well, your question was about decision making and least restrictive decision making. See, to me, as a former public servant, that's just good decision making. That's due diligence. That's being citizen centred and thinking about people at the heart of policy decisions, right? So I've always found it difficult to understand why people are resistant to that idea, because I'm like, every Royal Commission ever has at the heart of it that people didn't think about people at the centre of policy decisions, and that they didn't listen when vulnerable people were telling them what was wrong with what was happening. And if you look at the recent ones, aged care, disability, NDIS review, it's all the same. Robodebt. It's that story over and over again. You didn't listen to our particular circumstances, and you made decisions that you couldn't defend or explain. And I think in the era of big data, this is much more important. It's got to be explicable and not the greatest good for the greatest number all the time in the least time possible, which is the default of many policymakers. We just got to get stuff done fast, which means that you don't think carefully of who might be left out. The example I give to people is, at the beginning of COVID, there was a requirement for people a legislative requirement not to go further than 5 kilometres for your house to buy groceries, which was catastrophic for all the majority of Queenslanders who don't live in capital cities, right? You know, a lot of them couldn't buy milk within a 5 kilometre radius. So it's just that taking the time to think about decisions And I use that because that's an example everyone can immediately understand. They can understand why it happened in the first place and then what was wrong with it. You know, it was just a case of, don't assume everybody lives in southeast Queensland with milk and bread within 5 kilometres. This is not the way our state is. Think a bit deeper about how this decision is going to affect people and what is the least restrictive way of people's rights that we could make that decision happen. It was quickly corrected, so that's why I use that one, because it was one that the government went, and changed pretty fast to respect people who didn't live in urban centres. But, you know, it still happened. Right? We still have a habit of just making, especially under pressure, making laws that are utilitarian and don't think about more marginalised people.
There's a question that's come in which is quite interesting on what we've been talking about the complaints process and whether you know, that actual right to complain or right to be in a conciliation process, and they've used an adjective fair, you know, fair, so that gives it a type of quality. Should that be you know, should that be embedded in the Act? And you know, they're talking about obviously the Human Rights Commission or QCAT as a right to a fair conciliation.
Well, both those entities are themselves bound by the Act. So, and there is the right to kind of fair treatment based in, was certainly embedded in the QCAT legislation. So, yes, I mean, the conciliation should be fair. That doesn't always mean you get the outcome you want, but the process should be fair. Yeah, absolutely. I mean, looking at the complaints provisions under the Queensland Human Rights Commission framework inside the Human Rights Act, it is very clear that it should be a fair process and a transparent process. The problem is what happens if you have a complaint that's upheld but unresolved. It goes nowhere at the moment. So the Human Rights Commission says, yes, your rights have been breached. Yes, we've attempted a conciliation. No, the government department or public entity has not come to the party. And what? Just sits there. And then it's published. And maybe one of the things we should think about is, you know, how can community organisations make more out of those, you know, to solve structural problems. I'm very interested in any feedback loop, you know, where we're seeing patterns of discrimination or problems. What are we doing to stop someone else having to go through the complaints process? So I'm very interested in that.
That makes me think about the resourcing issue, because I know that when the Victorian Charter was introduced, it came along with some investment to make sure that not just the government but all public entities and community legal centres, etc., had the resources that they needed to make sure that the Act was properly implemented. In Queensland we didn't see that investment.
No, not even inside government, to be honest. And that is a real problem. And I mean, it won't be any surprise to you that I'm a big supporter of the community legal sector. And you know, frankly, just looking at the complaints, you know, only 3% of people making Human Rights Act only complaints who had successful outcomes, only 3% of them were represented by a community legal centre, because CLCs don't get funding for that work. And it's outrageous. Again, you're much better off going through the discrimination route where you can get access to a community legal centre than you are going through the Human Rights Act. And that's not okay, especially when you're up against Crown law or, you know, really heavy hitters on the other side. It's this asymmetric power that should be the first thing that a Human Rights Act should be trying to even up. So yes, in terms of both human rights education roles, but also making sure people are supported when they go through those processes is really important. And it's the way you make systemic change as well. We know that, right? We know that's the way you make systemic change. I've seen it in the disability rights field where people have good support through advocates. They have much better outcomes and the system is better off because of it. So that's definitely what we want. So you see what I mean? It's sort of inverted. It's like the thing where you should get the most support, you get the least support from everybody.
Yeah, it makes you feel a bit crazy sometimes.
Well, yeah, and I can understand why people go, well, If there's no remedy and you can't go to QCAT, then we'll put all our effort over here in the discrimination kind of bucket. But some people are going to have human rights only complaints.
Yes.
They won't have a discriminatory factor, especially prisoners. So, you know, what's going on? We've got to make this a process that is meaningful for people and not human rights denying in itself.
Do you think then your recommendations will go somewhere toward making recommendations about resourcing?
Oh, yes.
To support better implementation?
Yes, inside government, inside the Human Rights Commission, inside community legal sectors,
And the community sector.
And the community sector more broadly, absolutely. Especially especially in the emergency role, in your emergencies role. I think that's really important. Neighbourhood centres, you know, community organisations. People's rights are going to be... Look, I'm a climate justice person. Of course I'm going to say this. Queensland is up against it in the near future. We're going to have more and more difficult weather and natural disasters that are coming at us, and people are going to be very vulnerable, and they're going to need the community sector to be in their corner with rights-based approaches that preserve their dignity in these very difficult circumstances. And so, to me, human rights and humanitarian responses, they should be very closely entwined. And I think we've got a way to go, and also in disaster risk reduction. I see a very crucial role for the community sector there, but also this systems advocacy. I think the community sector is best placed to do systems advocacy, and that is such a strength of the community sector. And that's what we want for the dialogue model to work. You can't have it both ways. You can't say we have a dialogue model where we don't allow anyone to get damages and use the courts, and we don't support systems advocacy. That's not... No. You can't have it both ways.
No, I think the community sector has this really interesting role when it comes to building our human rights culture, because on the one hand, many of our organisations or workers are accidental advocates. They're not lawyers, they're not seeking to help a person they're working with necessarily assert their rights, but they might be the person that is most trusted in terms of hearing the story and then being able to support someone toward either seeing a lawyer or making a complaint to the Commission, or even simply asserting their rights in their interactions with a service provider, for example. But as well, many of our members are public entities themselves. So while they're not government departments, they're still caught by the Act as a functional entity, because they're performing a public service and funded with government funding. And I think there's been, you know, in some instances it's clear that you're a public entity, and in others it isn't. And we do know we've had members who have themselves been the recipients of complaints and have worked through human rights complaints with service users. I think it's incredibly exciting sort of progression of our sector itself, being originally having a charity mindset where you're the powerful actor, and it's through benevolence that you're providing support, whereas a human rights framework would say, well, actually the citizen has an entitlement to a service. We are receiving public funds and we're required to deliver that service in a way that is compatible with human rights and respects the dignity of the individual. So I think we're in this really interesting place.
I lived through that too. So I used to be the head of advocacy for the Australian Council for International Development, or the big aid organisations and smaller aid organisations that deliver ODA overseas. It was the same idea. We were mainly a volunteer sector and welfare driven, often religious organisations, and it was that process of professionalisation and keeping the values, but understanding that a complaints culture is actually really a gift. You know, it's saying we are duty bearers and rights bearers in conversation. It much more speaks to that solidarity of, you know, you don't deserve the situation you're in. We are working in solidarity with you, and our primary front of mind idea is your dignity and preserving your dignity in this relationship. You know, it's a different way of thinking It's taken a while for the aid sector to evolve, still a journey, but I think it's a really important one. It is that sense of, I hear it a lot from people who work with homeless people, people who are suffering precarious accommodation, you know, that sense of really deep shared solidarity with the people that you're working with, that anybody could flip that equation at any time, right? That's what
right.
it is to work with homeless people, that you could yourself be unhoused pretty easily, most of us. So it's like that situation of working much more with respect and dignity, those kinds of frameworks, as opposed to kind of you should be grateful for what I'm doing kind of mentality. It's a difficult thing, right? It's a difficult, especially when, you know, for a lot of not-for-profit organisations, there's so much regulation on people and so many demands by funders, and you're often caught, I think, in between a rock and a hard place.
Yes, yeah. I think the thing that I've noticed is that there's this very strong alignment between the values of our sector and human rights principles. And so while some regulation can be difficult, I think by and large this legislation is embraced by our sector, and we've seen some really excellent work of organisations really trying to grapple with, well, how can this improve the way that we work with service providers? How can we improve our decision making? A willingness to examine that, which has been really exciting.
I think that's right. That ethos of service, of commitment to public goods, and it's a beautiful thing. And people don't have to be lawyers to recognise unfairness when they see it. We know, frontline providers. If you look at the people who exposed robo-debt, it was all the frontline people. It wasn't the fancy executive lawyers. In fact, they were part of the problem. So I am all in favour of community people who understand injustice and an emotional and values level should have the courage of their convictions, and, you know, certainly, you know, enlist your human rights lawyer friends to help. You know it when you see it.
And I think that's a really good encouragement to everyone online, is to not be shy to engage with the review, because I think what Sue's saying is that, you know, your insights working in your community and with some of the most vulnerable people in our community are very, very valuable for this review, both in terms of understanding where the Act is working, but also things that aren't going so well. I don't think we need to be the experts in working out how that would be improved, but that is really valuable expertise to be providing back into the review. So I wanted to go back to, we were talking about the fact that we have human rights legislation which is similar, not identical, in the ACT and Victoria. ACT's was introduced in 2004, Victoria in 2006. So we've got quite a bit of learning outside of Queensland that we can draw on. Those acts have been reviewed and recommendations made. You pointed to being involved in the ACT review. So what are some of the things you think that we are able to learn from those other jurisdictions at this time?
Yeah, well, we basically went through all the reviews and looked at the recommendations again for each of them to see what's something that we should bear in mind for the Queensland one. A lot of it is around resourcing. A lot of it is around the training requirements. There's a lot in there about contextual training. So in other words, you can't just train people on what the Human Rights Act says. You have to help people understand this is what it means for corrective services. This is what it means for child safety. This is what it means for the Department of Education. This is what it means for us in the sort of the work that we're doing. So we're always saying to people, you know, tell me what your kind of top 5 human rights risks are. You know, like, can you name them? What are you engaging with? Like, who are you most worried about? What keeps you up at night? You know, what are the stuff? And not because you're worried about it being on the front page of the Courier Mail, but because you're worried about those people and the vulnerability of those people and that system. So that's the sort of thing I'm interested in talking to people about. You know, what are the biggest risks? So the training at the moment, There's some very good training, but not enough of it. So really helping people to kind of come to grips with it. And also because the Act started during COVID, there hasn't been a lot of face-to-face kind of human stuff. So definitely that need to keep that conversation going inside departments and, where possible, in kind of a co-designed way with people with lived experiences of those issues. And we learnt that, by now. You want to talk about disability rights, you might want to talk with someone with a lived experience of disability. You want to talk about what's happening with First Nations people, you might want to talk to First Nations people, that sort of stuff. Like it seems so simple, but it's clearly still not simple, and it's a complicated process when you have people inside, different people with lived experience who don't agree with each other, but that's all good, right? That's okay. But that doesn't mean that you don't get to listen to them and take on board that experience. So that idea of thinking about training in a kind of a much more 3D scenario driven way, the sort of way that you would do emergency preparedness kind of work, that sort of training at that sort of level, multi-agency, the most likely risks, what are we going to do and how are we going to deal with it. So lots about training. There's lots about the kind of more structural issues that have been brought up by the Act. So areas of how do you create a law reform loop around the Human Rights Act, which is something no jurisdiction's quite nailed yet. But you could see it sort of happening. So in Victoria and in Queensland, strip searching, for example, of prisoners, very problematic. Lots of Supreme Court decisions, lots of complaints. Same here, raised by the Women's Legal Safety Task Force, raised by the Prisoners Sisters Inside organisation. And so the Human Rights Commission did some work around talking to people about what was going on inside the prison system and whether there were other ways to deal with it, and leading to some policy reform. That's the way we want to see the Act working. So very interested in that kind of how do we use the Act to solve the problems? How can we use the Act in this problem solving way? And then there's lots in there about specific communities who were really struggling with the Act, so called communities, people in remote areas, that sort of stuff. So we've learnt a lot through going through those recommendations. Great. And I think resourcing is the tricky one. It is really core to having a successful Act. You have to invest in the things that you care about. The
change you want to see.
That's it. You have to invest.
So one thing we've been engaging in on behalf of the sector from at QCOSS is the move for a national Human Rights Act. Yep. And I know that in conversations with our interstate colleagues, there has been despairing comments made about, well, what's the point really anyway? Because, in Queensland, they just override these things, and what's the use of a Human Rights Act anyway? And we're often feeling that we need to defend our Human Rights Act and say, yes, that override is disappointing, but that doesn't rule out all of the benefits that we've seen. I think, the Human Rights Commissioner, when the override occurred the first time, I think, described it as deeply concerning. You've talked a little bit already, Sue, about other options, but what do you think we've learnt from that when we had some really significant human rights issues occurring, and to enable those things to happen, the Human Rights Act was overridden?
Yeah. Well, I think the problem with Queensland that we do have in the ACT, but we don't have in Victoria, is the lack of an upper house. So, government can move to a legislative solution very quickly. It can, especially in those cases where there were amendments, sort of, it was all very many issues with the way the amendments were passed, especially the second set. So I think there is this unique problem with Queensland in the sense that we don't have a series of checks and balances that other jurisdictions have. And, even without a national human rights framework. A lot gets done in the Senate that we don't get. So Queensland really needs a Human Rights Act. Very, very much needs a Human Rights Act because it's in this very specific situation, not having an upper house. So there's that. So the government, when it wants to, it can kind of flick on a dime in a way Victoria can't really get away with, and neither can the national government for all its attempts. One thing I will say is, would the greater public had noticed it had happened if it wasn't for the fact that we had a Human Rights Act that had to be overridden? I think that it does, and I've always felt this, it helps us understand and lays bare that the government has known it's a breach of human rights and done it anyway. Very powerful. So even though it's terrible when it happens, it does lay it bare in a way that you didn't get before the Act was passed. You know, there were breaches of human rights in Queensland pretty regularly without the public kind of being aware specifically that the government knew, did it anyway, right? Like, that is powerful, and I think it helps advocates make the point. So there's a couple of things we've been thinking about. You can get rid of the provision. As I said, the ACT survives without it. I think it's unnecessary because you've already got these very detailed limitations in the Act as well on rights. You could say that if you look at the Act, it says you can only override when there's an emergency. It's very clear, and the emergency in this case must be the community safety because it's not an earthquake or something. So, you know, it's got a very high level of when you're allowed to override the Act because of an emergency. And I don't think that these two situations came anywhere close to what the average human would call an emergency. And to be able to justify that it was an emergency, you'd have to have some evidence base, which they're not going to be able to point to in this case. You can say there were people who are upset about youth justice, but you wouldn't be able to point to the fact that this is a solution to those concerns. And of course it hasn't been either, has it? It has created more problems. I think it will be challenged. My understanding is there's already a challenge on foot to say that it was not a proper use of power because it wasn't an emergency and because it's led to some really horrible outcomes for child detainees in watch houses. So there might be some challenges, I think, to the whole premise. But you know, also, could it just seriously 5 years? It's outrageous that it only has to be looked at again for 5 years. It has a 5-year sunset clause on the override. That's not okay either. So we could say, one of the things I've been thinking about is how about government is asked to issue guidelines on what it means to have an emergency in this sense, so that they're held to account around individual situations. So if they could get an advice or make clear their advice that this is what they think is an emergency that deserves to override the Act, bearing in mind they never overrode it once during COVID. So, you know, that would have been actually acceptable if they had, but they didn't, right? So, you know, that's interesting to me. They chose to really balance rights in a very careful way, and they might not have always got that right, but they did attempt to. So, you know, we could ask them to pre-publish their opinion about when they're going to, under what circumstances would they use that override provision. We could say it goes for 6 weeks, not 5 years. We could say that they'll undertake to share that with the opposition or have it go to a committee, or, you know, have some sort of scrutiny of that decision before they go ahead with it. I did ask the previous Victorian Solicitor General, has there been any attempts in Victoria to deal with the override provisions? And there haven't. But the whole point of the Act, those dialogue models, is a sense of proportionality. So it's so carefully determined in the rest of the Act, and then to just throw it out the window. You know, for what? For sort of populist...
To look tough.
To look tough, when it doesn't achieve the outcome. So if you were looking tough but achieving the outcome, it would be a different debate. But that's not the debate we're having. I haven't seen anyone who thinks it's going to have an evidence-based effect in the way that would actually solve any particular problem. So yeah, it just feels very depressing.
Room for improvement.
We can certainly make some very strong recommendations about it, but I think what the government hasn't understood is that it demoralises other departments, other portfolios, other areas where they do not want people demoralised about human rights. That's the issue too. It sort of sucks all the energy out of all those champions inside government who think, well, what is the point if they're just going to throw it away?
But we've got to hold on to, that there are good things happening as well. It is demoralising.
That's it. But also, I do think it's really important that at least it makes it a human rights debate.
Yes, that's right.
And that people, you wouldn't have got the front page of the Courier Mail, that the Human Rights Act has been overridden before the Act was passed. It just would have happened, and maybe we wouldn't have even known it had happened.
Yeah, and getting a conversation up about the human rights implications of the decision would have been near impossible.
That's it.
Another element I think that's interesting is and this connects back to, as I said, we're kicking off National Reconciliation Action Week with the theme now more than ever, which is about continuing the fight for First Nations justice and human rights. Our Human Rights Act is absolutely a vehicle for that. Right now, the preamble of the Act recognises the right to self-determination, but it's not a right specifically protected in the Act. So will you be making recommendations about that?
Okay, so hang on, say that last part again. So
the right to self-determination reflected in the preamble, but not in the statement of protected rights.
Gotcha. Yes. So people have already talked to me about Article 28 in particular. So in some way, this is the cultural rights of First Nations peoples are protected in the Act, and that is, again, quite special to Queensland. And the idea that it doesn't make sense to protect the cultural rights of First Nations peoples without respecting their self-determination in an explicit way, that those rights come from the UN Declaration of Rights of Indigenous People. It's embedded in the sense of self-determination. So to me, that makes perfect sense that Article 28 be more clearly articulated in that way. But of course, it's not just cultural rights that depend on self-determination. So I really, really liked the way those issues were dealt with in Waratah Coal. So we do have some really quite decent jurisprudence from the Land Court on the proper interpretation of the Act that would respect self-determination. But I think it's better to make it explicit in the Act. So yes, I do support that. And I feel like in the absence of, or we won't know about the pathway to treaty, we should make the Act at least make sense. It's Queensland is a settler state, it has a colonial past. Its Act should speak to that history. It should speak to trying to have a different future. So the right to self-determination, I think, makes perfect sense. Yes, I think it's really important. So the question is where. I think it should be in the operative provisions or something that's an interpretive provision that says all the rights should be interpreted around thinking about the right to self-determination under DRIP. So that's. I want there to be something quite specific about that, because otherwise, again, it just loses its relevance to the future for Queensland, don't you think?
Oh, look, I think it would be very future focused to be legislating rights that are contained in the United Nations Declaration on the Rights of Indigenous People, given it's a declaration, not a treaty, and so it's really turbocharging then the way that the impact of the recognition of those rights. We're having some really awesome questions coming in, so thank you. And it's going to kind of loop me back to what we were talking about before. One idea someone's had here, Sue, is with the override provision, whether that should be actually something that the government needs to apply to the courts to be able to achieve. So there's some, I guess, rigour around whether that's available.
Yeah, well, they'll say no because there's that you could get the Supreme Court to issue a statement of incompatibility, for example, like the ACT, but they'll say that the whole point of the dialogue model is that the judges can't override the Parliament. So I would say the government will have a very nope.
Yes. Yeah. No.
But you could get an advisory opinion that say this is the proper way to interpret that provision, and the government could volunteer to be bound by that. And that would be, could get a retired judge like Justice McMurdo or someone to say, this is the way, if you're going to use an override provision, these would be the circumstances in which it should be done. Because if you look at the ICCPR and the ISESCA, they also say, so under treaty law, it says that, human rights are not absolute in a time of deep emergency, civil conflict, disaster. The government can suspend human rights for short periods of time. There is this understanding that, there might be times when it's just not possible. And even then, it doesn't apply to the right to life and torture and various other kind of non-derogable rights. So under the treaty law in which the Human Rights Act sits, there is this idea that there will be times when a government can't do the full panoply of protection, but they're for really serious reasons. They're if an earthquake has ripped your territory apart, or you're under attack, or, not what we're talking about here. So it's having some clarity around that to say those provisions are for actual emergencies, not political emergencies. They're for actual emergencies, and have a rigour around that. That is compatible with the international human rights law, and that's kind of where we want them to go.
So you have a fairly epic task ahead of you, a really important piece of work and short time frame. So I think you've got 6 to 7 weeks to consult, talk to stakeholders. That's government, that's NGOs, that's all across and hearing you reflect on your origin story and the importance you place on the voices of those who don't get the opportunity to be heard, and people in rural, regional and remote communities. What is your consultation and engagement plan?
So I'm going for every rural and regional newspaper and radio station. I'm going to Torres Strait and Cairns and Palm Island and Townsville and Cherbourg and hopefully Mount Isa. And just doing as much kind of regional radio as I possibly can. I'm very reliant on community organisations that are in various places to help get the word out, get the good word out. But it's not ideal, and that you'll notice 20th of September is right up against caretaker. So it's a really hard deadline, right, because of caretaker. I might get a couple of weeks either side, but I don't think so, because it'll have to be tabled under caretaker, and then there'll be an election in October. So some pretty tough deadlines. It would have been nice to have the review a little bit earlier than it has been, but we will do our best. And as I say, I really mean it. The direct voice of communities, where I can include that in the report, I am completely committed to doing so. So if you can make the effort to get me people's voices, they will be commemorated in this report and amplified in this report. So it's worth the effort if you can manage it, and we'll be trying our very best to do that. But yeah, the report should be for everyone in Queensland, every single person in Queensland. That also means young people and children, people who are not Queensland citizens but here on the territory. I'm thinking about Pacific workers under the PALM scheme. I'm thinking about, backpackers. I'm thinking about anybody who's in Queensland, on Queensland territory, is someone I can cover under this Act. So, and it doesn't have to be, if you get us a submission, it can be by video with the face screened, and it doesn't have to be in writing. So you can send me an audio file or a video file. It can be in any language, and we'll get it translated. Anything, any way you can get to me, we will consider. So that's part of what we're doing, and we're going to also make copies of the findings of the report, the recommendations, in an easy read version and have an interpreted version. So there will be some genuine efforts to make it as accessible as possible. Yeah.
So you kind of touched on this, Sue, but your report is due at not the most ideal time in terms of achieving the recommendations that might be made. So what's your thinking in relation to that, and how we can all make sure that this very important step in the journey of better human rights protections in Queensland, a greater human rights culture, that this has the biggest possible impact?
Yeah. Well, in this sense, it doesn't change in any way the way I would have done the report anyway, because we really want to do the best job we can. And, this is a genuinely bipartisan issue. This is an issue that should be dealt with on the basis of the best evidence for the best outcomes for the most vulnerable people in our community. So that's not going to change in the way that anything's done. It's just a lot of uncertainty. We won't know if the government... We know it won't be the same Attorney General. She's made it clear that she's leaving politics, is my understanding. So we know that. It'll be a fresh person, whoever it is. But I always think we write these things for our kids to read. We write them for our grandkids to read. Like we write them because we have hope that there's going to be movement, and it doesn't have to be this election, next election. We have to really think long term around this. We have to write what we want to be remembered for. So that is my aim. What do we want to be remembered for? Us now. What are we going to be proud of? That's the report that we're going to deliver. I've never been so great at politics anyway, Aimee, as you know. I just don't understand what goes on most of the time. I'm like, why would they do that? So there will be no political savvy around it because I don't have any. But there will be a genuine attempt to make this report just appeal to people's good sense, and hopefully on either side of politics have a whole range of things that people go, that makes sense to me, and this looks like good outcomes for the community, so I'll give it a red hot go. That's what I'm hoping. Yeah.
I think obviously all of us want to engage in the review with the primary purpose of seeking strong recommendations that could then be implemented and move forward. But that's not the only thing that's achieved through a review. Just we think about how regularly reviews of the other acts are referred back to, how much we all learn from them. The Brett Young review that was done in Victoria so long ago helped us immensely with our campaign to get a Human Rights Act. So I think, we can't be too cynical about it or too depressed about it. We have to engage in good faith and make the most of the opportunity.
Yeah, and my experience is that good policy, well explained or well described and with the right rationale, does transcend politics. If you have the best chance at explaining why this is good for Queensland, and with the most support we possibly can, then that's the way you have to proceed, and hopefully it will find its audience.
Yes. There's been terrific questions and suggestions coming through, and I just want to give you the assurance that we are receiving them, looking at them. We also received
open
pre-submitted questions, and we're going to take these into consideration in our work and provide them to Sue and the review as well. Sue, a question that I thought was really interesting related to the outcome of the Disability Royal Commission and that recommendation that we have a federal Australian Disability Rights Act. So the question is, how could that recommendation be taken forward through this review?
Yes, I mean, at the time I was like, I don't know how I feel about having a Disability Rights Act in the absence of any other rights protection. Then I thought, no, we've got to start somewhere. And if it's going to start somewhere, it's great that it starts with people with lived experience of disability. So, but it was just like, how would that work? And aged care also has a reference to rights, and that's because these royal commissions are the way we do human rights in this country. We wait until everything's gone horribly wrong, and then we go, what would make things better is if we recognise people's rights and inherent dignity. So what's coming under the NDIS review is really important for states. So there's this idea that the NDIS will carve out what they call foundational supports. They'll be around education, housing, employment, and they will go back to the states, or go back. They've sort of never left, but it's all been a bit murky, right? So the role of the states in the NDIS and this kind of symbiotic relationship is going to become very important over the next couple of years. And then state mechanisms around disability rights are going to become very, very important. So if you've got people who are engaged in that NDIS thing and think state stuff is not so important to you, it will be very, very soon. They're absolutely having the huge arguments about it at the moment, and what kind of money is going to be where and what's it going to look like. But in terms of most people's core living standards, it's still the states that are fundamentally important to that happening. So yes, disability rights at a state level are absolutely crucial. Issues around restrictive practices, issues around supported decision making, they're all still state level issues as well. So please do think about that. It's something that I would love the Act to be interpreted around particular demographics, for example. So I'd like to think about what's in the Human Rights Act for someone with a disability. How does it look? How should it be interpreted? Again, context and strategy around it. What does this look like for a child who is in out-of-home care? What does the Act mean for them? What does the Act mean for our experience, our relationship with the natural environment? You know, Waratah Cole did a really good job of kind of laying that out. So we need to think about the Act from the perspective of the person who it's designed to protect, or ecosystem it's designed to protect. You know, what does it look like from that perspective, and how do we make it easier for those people to use it in that way? So that's really important. But yes, the states are going to be coming back with a vengeance when it comes to, you know, who's going to have the most responsibility around someone living their life with dignity, with full participation in society. It's going to come a lot back to the states again.
We're going to pause.
Okay.
We're going to see if we've got time for any more questions, but we're going to go to you online and collect a little bit of your feedback. So we've got a few polling questions for the audience, and it will come up on the screen. So the first question we have is a simple yes or no question. Do you support having a Queensland Human Rights Act? Keep going. The second question, are they all coming up at once? Yeah. The second question we have is another yes or no one, and it is whether the Act helps deliver positive outcomes for the community, for service users and clients. Another question, are there areas where the Act needs to be strengthened? We're asking you directly, how is the Act improving a rights respecting culture in your organisation? So that hopefully is very specific to community organisations and how they're operating. If you've got some good stories about how that is or isn't working, that would be really great feedback. So those questions are there. We're collecting your feedback for the QCOSS submission and to provide that directly to Sue and her team for the review. And we've also captured all of the questions and feedback that you've put forward in the chat. I'm sorry that we didn't get to all of it. There was another one. There's so many good questions, and I'm just going to pinch your brain for a bit longer, Sue. I was thinking there's a question on there that's specific to people from culturally and linguistically diverse backgrounds and their ability to access their rights under the Act, potentially through understanding, having an interpreter. Have you seen things through your work, through the reviews, that would strengthen the capacity of people to receive good and accurate information, particularly when they're from a non-English speaking background?
I think this idea of disinformation is going to become so important. In relation to interpreters, I have experience. I used to work for UNHCR as well as for ACFID, and we heavily relied on interpreters for our refugee status determination. And yes, I know that it can sometimes not with any ill intent, you can just get the wrong dialect or just have the wrong interpreter for that particular group. and sometimes sort of deliberately misleading interpretation. It's a very difficult profession, like any other profession, and should be held up to the same standards of quality that other professions are. So I don't know if it'd be a breach of human rights law rather than a contractual breach, but there'd be a range of issues that's wrong with it. But called communities deserve to be participating in public life on the same basis as other Queenslanders. That's the bottom line. And that their social participation should be, barriers to their social participation should be removed. That's the key. So wherever those barriers are, we should be trying to seek to withdraw those barriers. And I think here, the range of issues that core communities face is I was hoping that the multicultural review would come out by now, the Multicultural Australia review. I've been waiting for that for ages, and it's like, where is that? That's been forever. I'm really hoping there's some really good information in there about specifically, what we can do to break down some of those barriers. What does a multicultural Queensland really look like? What could you expect to see in a multicultural Queensland? So you see, a lot of the time when we're thinking about rights and the Human Rights Act, it's phrased often in the negative. You have the right not to be interfered with by police or whatever. We're trying to think quite positively of what would a truly inclusive Queensland look like? Can we imagine it? What would have to happen for us to get there? That's the sort of stuff I'm really, really interested in. And I think for called communities, we've never really had a picture of what that might look like. What would be a vision of a fully integrated, fully inclusive Queensland? What would that look like from a called perspective? It's the same with disability rights. We've never had a society that fully valued the lives and status of people living with a disability. The same for gender equality, right? We've never seen it. We have to kind of imagine it, what it would be like.
Unless we've seen the Barbie movie.
Unless we've seen the Barbie movie or been to Finland. Yeah. But it's one of those things where it does require us to have a bit of imagination and a bit of ability to imagine a future that we don't currently have. And that's also what's beautiful about human rights. You can hope for something better and you can help build it. You've got to be able to see it to get it, to build it. So I think for called communities, there's more an idea in human rights law about what you shouldn't do to called communities, but we want to also have a more positive view of how to include people. What does it look like to be fully inclusive?
It reminds me of this beautiful thing I've heard Professor Megan Davis say, and she's a Queenslander, as you know, say about law reform work, but I think it equally applies to advocacy in general, is that it's the work of the imagination, that we have to believe in something better in order to advocate for it or fight for it.
She was saying this week, I've been, probably like many people, I've been pretty depressed about the aftermath of The Voice. And she was saying, what about all those 6.2 million people who voted for change, who, deeply wanted change? I was thinking, that's true. I should be dwelling in that possibility. Those 6.2 million people who want something different in the future, and be quite compassionate for people who probably didn't understand what was on the line. Again, a lot of disinformation around the Voice campaign, and I think these ideas of the right to truth, online and in public life, it's going to be harder and harder to make sure we get good information, accurate information. It's really important to think about that. That's why the digital rights are kind of on the agenda for future rights. Most of us are going to get our information online. What is it going to be like to live in the world without access to the internet? The right to be forgotten, all those interesting things. That's the future of our children probably depends on those digital rights more than anything else, right?
It's so interesting to think about human rights issues and the future that we imagine and how we can help create that through better laws, because on the one hand you're dwelling in sometimes in the worst of the worst when you're thinking about human rights breaches, and on the other hand you're dreaming of the best in terms of what we're wanting to achieve. And another little line that I hold on to inspire me in advocacy is some words that I heard Mick Gooder say, and he says that the greatest weapons against progress are cynicism and fatigue. And so when I reflect on things like what's happened in the youth justice space in Queensland over the last few years, the outcome of the referendum, and other things that we see happening in our community, I can see people on the chatter talking, for example, about the treatment of children with a disability in the education system, that we can sort of reflect on the things that need to change. We can allow ourselves the emotional space to respond to that, because that gives us the energy to kind of do something with it. But I think this is an opportunity to not be sort of weighed down by cynicism and fatigue. We have a review going on of our Human Rights Act. We have an opportunity to put forward a better vision for our state to improve the rights that we do currently have that are incredibly important. I think this is an opportunity to create a public record that demonstrates the support in Queensland there is for human rights laws, for human rights protections, for a human rights protecting culture and state, regardless of whether all of the recommendations are supported. It would, if we have a lot of submissions, hundreds of submissions flowing into the review, it shows that there is strong support for this legislation. And I think that that is really valuable when we think about protecting against eroding our rights or going backward in this state. So I am just putting it on the line saying, please do provide your submission, please do participate in this review. Submissions are due by the 21st of June. That's not too far away. I know QCOSS is going to try our best to support you to put in a submission. As I say, anything that you want to provide to us for our submission, please, you can pop it in the chat now, but also you can email us at research@qcoss.org.au. In addition to that, in addition to our submission, we'll be putting a template out for people to use to hopefully make it easier to write a submission. And as well, our policy team are going to be coordinating a working group to help, or to not necessarily help, but to provide a collegial environment for the development of submissions into the Human Rights Act review. So if you do want to participate in that, shoot us an email at research@qcoss.org.au. I wouldn't be doing my job if I didn't do another shout out, which is to say, and something we've discussed Sue this afternoon, is that we do have some really significant human rights issues occurring in our state right now, every day, every night. There are children as young as 10 being detained in adult watch houses in Queensland, which is really an unacceptable breach of human rights and is causing pain and trauma to so many vulnerable children in Queensland. If you could, we would love it if we're going to put a link in the chat. We are encouraging as many Queenslanders as possible to email the Premier and throw your support behind removing children from adult watch houses in Queensland. It should be a really easy action to take. You can just literally click on a few buttons and the email will automatically go from you to the Premier. So I want to just thank you all so much for joining today. Huge gratitude and thank you to Sue. Again, such a wonderful thing to have Sue Harris-Rimmer leading the review of our Human Rights Act. She has been a part of this act from the beginning, and no one's better placed to lead this review. Thank you, Sue. Thank you for welcoming this review with an open heart and such an amazing mind. And thank you for today and best of luck with your work.
Thank you. Thanks, everyone. I'm really grateful that you've made the time to be here. I'm deeply grateful, and the very best of luck with all your important work.
We're just going to put up an evaluation poll that we're hoping you can answer before you jump off the session this afternoon. But again, thanks so much for attending.